All right, welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here so I can acknowledge you. And is it warm to y'all? It's still blue.
My threshold and your threshold are always different, Judge.
That's not true. That is not true. Matthew Gould. Christian Grindell. Jaquavian Jackson. David Pesnell. Preston Wilson. Preston Mitchell Wilson. Lisa Peace. Royce White. Randy Palmer. Shelby Stanberry. Stina Ross. Ms. Ross will be appearing via Zoom today with court's permission. I see Ms. Ross in the online waiting room. We'll recall her. Katrina Anders. Here. Robert Bates. Here. Michael Bowman. Michael Dwayne Bowman. There's a waiver on that one. Thanks, sir. Brad Brewer. Jason Briggs. Sicorian Fulbright. Sydney Hip. That was here. Shelby Hood. Sorry, you're right. Sit there. Pretrial set juniors. Kirkland Huggins. Jacob Myers. Jessica Swindle. Jessica Swindle. Adam Chronister. Waiver of arraignment filed, approved, pretrial set June 15th. Daniel Payne. Wendy Price. Mary Robinson. Isaiah Valencia Fulton. See outside. I think I saw him with Mr. Noriega. William Hayes. Thanks, sir. Try to leave the rest are 9:30s and 11s. Do we have anyone that's ready, counsel?
Yes, Your Honor, good morning.
Good morning. How are you doing?
Doing very well. On William Hayes,
Yes.
Judge, we made significant strides in this case.
Let's let him get up here so he can be a part of this hearing. This is cause number CR 22-300 through 306 consecutively. Go ahead.
Yes, Your Honor. We made significant strides in this case, in these cases, Your Honor. If we can get another setting, I think in June, late June would be a very good thing to get work out the details.
Where are we going with it? Are we going to trial? Are we going to?
It does not appear to be a trial.
You are going to trial?
No, it does not appear to be a trial.
So if I set it one more time, we can have it wrapped up.
I sure hope so. That's my belief that we can get it done between now and then.
Doesn't sound very confident.
With Curry's case, I know there's been a lot of communication back and forth. I believe one more reset will give us the final answer one way or the other.
Okay. All right, court, we'll set this for a final docket call. You said late June. What about June 27th?
That'll work, Your Honor.
Okay, court sets Mr. Hayes for final docket call, June 27th. On that day, I'll expect to hear whether there's a resolution or request for some type of trial.
Thank you, Your Honor.
And Mr. Hayes, I want you to check in with pretrial release. I show that you failed to report on April 23rd, pretrial release. So just check in with them, and then if they tell you you're free to go, you're free to go. Otherwise, just stick around. Any other council ready? I'm ready to screen. Lisa Ann P, CR 22-389. This piece is set for pretrial today, Mr. Green.
That's correct, Judge.
Any contested pretrial motions?
Judge, I do have a motion to suppress evidence that I filed.
You're wanting a hearing on that?
Yes, Judge.
Set you as early as May 30th or June 29th.
What was that second date, Judge?
June 29th.
Which I think based on my current schedule, that June 29th date would be more appropriate. Let me check this to make sure that that's in the 9 o'clock in the morning.
Yes.
That'll be fine, Judge.
All right. Court says Ms. Peace will hearing on motion suppressed June 29th at 9 a.m.
Judge, if I might,
Yes,
state
ma'am.
has filed a response to Mr. Green's express, served on him this morning. I just wanted to make the court aware, because sometimes it goes to the clerk, sometimes it goes to you, Judge, so I just wanted to let you know it was in there.
Okay, thank you.
That's now, I haven't seen it, but I trust that I will get it at some point.
Okay, all right. Ms. Peace, we'll see you back on June 29th, but I want you to check in with pretrial release. They've indicated to me that you failed to report in April, so I want you to check in. Mr. Huber, how are you this morning, sir?
Morning, how are you doing, sir?
Doing great. Ready on Brandy Palmer? Mr. Palmer, CR 22-386-387. Except for pretrial, Mr. Huber.
Judge, we're set for pretrial. After our last pretrial hearing, I met with Ms. Curry, she's assigned to the case, or she's taking the case. We're still waiting on discovery, specifically car camera, body cameras from DPS, from the sheriff's office, updated property report from Van PD, and office reports from the sheriff's office, Constable Pat Jordan, and any other agency that was involved. I haven't received those yet, so if we get another pretrial date, that would be wonderful. I know Ms. Curry's been trying to work on this, but I haven't talked to her in the last week or so about that.
The update from the state.
State is unaware, Your Honor. Mr. Hugler said he spoke with Ms. Curry, so I'm sure she's aware and she's working on it, but I don't have an update for them.
All right, Mr. Huber, since you don't have those things, I'd be willing to push you out a little bit further so that you can get those reviewed and file any pretrial motions.
It'll depend on what the discovery shows, Judge. As soon as I get it, I'll file motions.
Do you about July 11th or 13th?
July 11th works, Judge.
July 11th. Okay. All right, court says Mr. Palmer then for pretrial July 11th, it'll be at 9 a.m. Once he signs and gets the yellow copy, free to go.
Thank you, Your Honor. That's all I have.
Yes, sir. Good to see you. Why won't you stay with us? It's, Shelby Stanberry. Mr. Huber.
I don't. Yeah. Say any times. Started on that.
All right, this is cause number CR 2194, State of Texas versus Shelby Stanberry. Ms. Stanberry, we're here for a probation extension. It appears to me that you're wanting to extend your probationary period for 1 year. That would extend you until May 10th of 2024. Looks like during the extension period, probation is indicating that they would be waiving their probation fees and your analysis fees. What is it that we need to extend your probation for?
I wasn't able to work as much as I was supposed to on probation. My dad has cancer, and so and my mom works full time. So I was the main caregiver plus my son that I had before I got on probation. I just haven't been able to pay fees.
All right, so this is something that you're wanting to do so that you can stay in compliance with your probation conditions. All right, the court will approve the probation extension for Ms. Stanberry. The court extends her community supervision period for 1 year. The new expiration date of May 10th, 2024, the court will waive the probation fees and your analysis fees during the extension so that Ms. Stanberry can pay her fees. All right, Ms. Stanberry, I've signed the amendment to a hearing probation. We'll get a copy. It's ready to go. State, I'm gonna bring in Ms. Ross, is doing Mr. Murley or Ms. Good morning, Mr. Murley.
Good morning, Judge. How are you?
Good, fine. Yourself?
Good. Doing well.
Ms. Ross is second to get connected. While she is connecting, this is cause number CR 21-143, State versus Christina Maria Ross. For status. She's about to. All right, Ms. Ross, I'm gonna go ahead and just ask you to unmute there.
Okay,
If you can you go ahead and just set your phone down a little bit so I don't get motion sickness? I didn't take my Dramamine this morning.
okay.
Just prop it up there, be nice and still. Can you see and hear me? Okay,
Yes, sir.
and can you see Mr. Murley, your attorney?
No, sir.
All right, he is in on this hearing. If you want to see him, you can just swipe left or right on your phone and you'll see different participants in the hearing, okay?
Okay, I got it.
All right, Mr. Murley, we're set for status today, CR 21-143. Any update from the state or defense?
Judge, the co-defendant's trial is special set in December, so we're just asking for another status either at the end of July, early August, whatever the court deems appropriate.
All right, and I show that there's still a delinquency, a financial delinquency on a pretrial release, Mr. Murley. Are you aware of that? Have you addressed that with your client?
Yes, Your Honor. How much is the delinquency, Your Honor?
I
300.
sent in a payment, it was yesterday, so it probably hadn't hit yet.
What did you pay yesterday?
$250.
Okay. All right, we'll check on that, and then at the next hearing, if we don't have, if we still have a delinquency, then we're gonna need to have a further conversation. All right, court will reset Ms. Ross for an additional status. Set in August, Mr. Murray Leader, you have your calendar available.
Yes, Your Honor.
8th, 10th, or 22nd. 8th, 10th, or 22nd. Your pick.
Your Honor, may we have the 10th, please?
Right, court sets Ms. Ross for status on August 10th. During your request by probation from the state to have Ms. Ross appear in person on that status date.
Judge, I'll defer to probation.
Okay, Mr. Ross, I'll approve you to appear via Zoom so long as nothing occurs between now and then that would change that, okay?
Yes, sir.
Meaning, if there's a concern that the probation department has because you're not paying or you're not reporting or doing the things that you're supposed to do on pretrial release, as long as we're okay on all of those things, then I'll allow you to appear via Zoom on the 10th, okay?
Okay, thank you.
All right, anything further, Mr. Murray Leader?
Oh, Your Honor, thank you.
All right, thank you. We'll be adjourned to this, you're excused. Thank you, Mr. Ross.
Thank you. Right. Is Felix Diaz here? Felix Alejandro Vasquez Diaz? I'll get Mr. Estrada and we'll get an announcement on Mr. Salas Merlo. He's in federal custody. Yeah, he did. I had tried an interpreter set up for Mr. Diaz and Mr. Gonzalez Merlo, but I don't have seen Mr. Diaz or Gil Alham. So go ahead and bring in Mr. Estrada. Morning, Mr. Estrada. How are you, sir?
Good morning, Your Honor. Pretty
All
good.
right. This is cause numbers CR 22-374 and 375 State versus Eugenio Gonzalez Merlo. What's the information that you have for the court?
Your Honor, Mr. Merlot is in custody in the state of Florida. I sent over by email to state a copy of his documentation of Mr. Merlot's continued custody. He's currently held without bond in the state of Florida.
Is that federal custody or state custody?
It's currently state custody, but I've been consulting with co-counsel Stephen Amster, and he's advised that he was approached by federal agents that they may be investigating for a federal case.
Your request on state?
Your Honor, just set it for status, Mr. Estrada and I have,
Turn that on, because I'm not sure that you can hear.
sorry, Judge.
It's okay.
Mr. Estrada and I have a agreement that's gonna take some time to confirm, but upon plea in Florida and some terms on our end, we're gonna resolve this case. So if we could have like a 60-day reset, just to give some time for the Florida court to work itself out.
All right, Mr. Estrada, let's set it. Set it mid-July. Are you available on July 11th or 13th? Or even July 6th, 6th, 11th, or 13th?
July 11th will work, Judge. I think I have a conflict on the 6th already.
All right, court sets Mr. Merlo then for a status on July 11th. That'll be at 1:30 if he's in custody, 9 a.m. if he's not in custody.
Yes, Your Honor.
All right, if there's nothing further in this case, we'll be adjourned and you are excused.
Thank you, Judge.
Thank you, Mr. Shaw.
You'll take care.
You too. Good morning. Is it Miss Bell?
Yes, good morning, Judge.
Morning, Ms. Bell, I have some news. I had two individuals that were gonna need your services, this morning. One of them is in custody in Florida. He's not gonna be appearing today via Zoom or in person. So we've already handled that case without his presence. The other individual, Felix Diaz, has failed to appear for court, as has his attorney. So I think they're trying to get here. However, I don't think that they're gonna make it in the time frame that we have you scheduled. So I'm gonna go ahead and tell you, I appreciate your time. Sorry for your inconvenience. I'm gonna release you so that you can go cover someone else if they need your help. Okay?
Okay, very well. Thank you, Judge.
Thank you for being here. I appreciate it. Next time, hope it goes a lot better for you.
All right, thanks. Bye.
Yes,
It's 22-00051.
gotcha. I got you.
21-00398.
398. Royce White,
Yes, sir.
come on, Mr. White. All right, court call for Royce White, and we are set for a docket call in each case. Go ahead, sir.
Your Honor, we believe we have entered into a plea with state. We are submitting our jury waivers today and we want to resend the case. I'd like to do my job, just look at the state's file, actually get a plea. The state needs to give me the papers, but we think we're on our way.
Okay, so we have the waiver of jury trial.
Right. Mr. White has some medical issues he wants to attend to before he comes back from the next event. And, like 5 or 6 weeks for that to happen so he can see his physician.
Is he undergoing some type of surgery or is it checkups? What is
He's got some issues with his congestive heart failure. He's got some edema and swelling issues he wants to deal with. Goes on.
All right, Mr. White, I'm gonna swear you in so that I can ask you some questions about this waiver of jury trial. If you raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. Put your hand down. Just speak out loudly and clearly for me. Mr. White, you are represented by your attorney, Mr. Herring, correct?
Yes, sir.
And today you've discussed with him a waiver of jury trial in each one of your cases. Is that correct?
Yes, sir.
I'm sure that he's explained to you that once you waive your right to a jury trial, you can't get that waiver or you can't get that right back in most cases. Is that true? You understand that Mr. Herring cannot waive your right to a jury trial. I can't waive it. The state can't waive it. No one can take that right away from you. But you can waive it as long as you're doing so of your own free will, intentionally, knowingly, voluntarily, because it's what you want to do and you're making a decision based on your case, and this is what you want to do. Is that what you're doing in this case?
Yes, sir.
You understand that once you waive that right to a jury trial, then your right to cross-examine the state's witnesses and their evidence in front of a jury is lost. You understand that?
Yes, sir.
And you understand that if you leave here today and in a week or two, you change your mind and decide, hey, I think I want to have that jury trial. You understand that that right will have been waived today, and unless there's very limited circumstances that will not be restored to you.
Yes, sir.
Understanding all of that, you're telling me today that you want to waive your right to a jury trial in each one of these cases and resolve your case by a plea bargain. Is that correct?
Yes, sir.
All right, and Mr. Herring, you join in with your client on waiver of his right to a jury trial?
Yes, Your Honor.
And I see here that the state has signed a waiver of jury trial indicating you will be waiving its right to jury trials. That's right. All right, the court then finds that Mr. White being admonished of the right to a waiver jury trial, it has done so intentionally, knowingly, and voluntarily. The court hereby approves the waiver of jury trial in each matter. All right, Mr. Herring, what about June 27th? That's around that 5 to 6 weeks. Yes, Your Honor. All right, court says Mr. White's plea do so on June 27th. That will be at 1:30. Mr. White, you'll report to the Van Zandt County Justice Center and we'll conduct your hearing over there.
Yes, sir.
All right, once you sign the notice of setting, leave the white copy, you take the yellow copy, and free to go. Christian Grindel. All right, Mr. Goodell, I see that our goals from our last hearing on your sanctions court was for you to pay $60 to probation, for you to work 25 hours of community service. It looks like did you pay your $60? My records say you did.
When I paid off my probation, everything, and paid on my probation, paid 3 months ahead. I didn't, make payment this month, but I did last month.
All right, well, what we're doing here is trying to get you caught up to speed so that you can expire on time. So you need to make sure that you're paying every month. Okay. Court finds that you worked 42 hours of community service. I commend you for doing that. You worked over the minimum 25. Next month, when I bring you back, I need $60 to your probation department. And I need that 25 hours of community service. That 25 hours is the minimum. That's what you have to work every month in order to get off probation at your scheduled time. Okay, so working the 42 is great. I don't want you to say, well, I worked, what is that, 17, work 17 hours over. So I'm gonna work 17 hours less next time. It's not gonna work that way, okay? Make sure that you're at 25. The quicker you get those worked, quicker you can get off probation even earlier, okay? All right, so I'm gonna bring you back on June 27th. June 27th. $60 to probation, 25 hours community service, okay?
Sorry, I can take care of it.
It's okay. No, it's okay. $60 probation, 25 hours community service. It's cause number CR 19177. Matthew Gould. Right, this is cause number CR 2389. All right, Mr. Gould, I think my records reflect that you've paid off your balance with your counselor, correct? All right, so that's good. Show that you made a payment on some of your court costs in February. The last payment was in February, so I need to make sure that you're staying up on your payments. Yes, sir. With your court costs. I don't know if this is this case or an old case, but you need to check in with Ms. Harmon down at the end of the hall. And talk to her about making your payment for your court fees. So what probation is recommending is that we release you from sanctions court today. Okay, so I'm going to grant that. I'm not going to keep on bringing you back to court because you've gotten into compliance. But I want to make sure that you're still paying off on your court fees. So while you're not coming here, I'm putting you back on. I'll put the ball back in your court, so to speak, that you're going to be compliant with your probation conditions without me intervening and keeping my thumb on you. Okay, all right. So you're released from sanctions court, free to go. Go down to the end of the hall, see Ms. Harmon, talk to her about payment on your fines and fees. Okay? Yes, sir. Free to go. Why you ready? Yes, sir. If you need more time, it's fine. I was just taking it around. Say it's just signing up. Who do you want to call first? Can you call Ms. Frost? Sure. Wendy Price, CR 22339. Ms. Price is set for pretrial.
Your Honor, we don't have any contested pretrial motion to abide by the board standing order. Any applicable time frames that are in that document. Yes, so
All right, court will set this price and for docket call. Got June 13th or 15th. Please go ahead. Let's set it for the 15th. All right, Ms. Price, court sets you for docket call June 15th at 9 AM. Once you sign, get the yellow copy. Be ready on next, Ms. Robin. Mary Lynn Robinson, CR 22-194. Your Honor, I've talked with Ms. Curry on this, we've reached an agreement generally on this. I'd ask for reset. All right, court sets Ms. Robinson for plea June 15th at 9 AM. Is that correct, Mr.? Yes, 9 AM. Ms. Robinson, free to go, yes, ma'am. You're free to go, yes. This is what you'd like to do. Anyone else, Mr. White? Mr. Payne, Your Honor. Daniel Ryan Payne. All right, Mr. Payne, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, lower your hand. Your name is Daniel Ryan, is that correct? And Mr. Payne, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that? Are you currently undergoing treatment or on medication for any of those? Okay, do you feel like you have a rational understanding of what's going on here today and that no way is your mental health diagnosis or issues clouding your judgment or making it difficult for you to understand?
No.
And you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case, that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No.
Okay, Mr. White, do you believe that Mr. Payne is competent today and to address the court on what Mr. Payne has indicated regarding the mental health issues?
I do, Your Honor, and if the court would red flag, we had gone through and I provided, I think I'd asked for a couple of pre-sales regarding trying to get some VA documentation. It's my understanding from looking at the documentation, there's Mr. Payne has a 100% rating from the Veterans Administration. After I had participation in state. He's been earning full services for eBay, as well as. This fancy volunteer.
Thank you, Mr. White. And Mr. White, you've explained to Mr. Payne, his legal rights regarding this plea agreement and also the advantages and disadvantages of deferred adjudication plea.
I have, Your Honor, most notably, he violates the term of condition. I'm satisfied that he understands this, that before we hold a hearing, or finds by preponderance of the evidence that he did in fact violate the term of condition of his probation. That the court would have possibly the entire range of punishment at its disposal, which would be up to 10 years penitentiary and up to $10,000.
Thank you, Mr. White. Mr. Payne, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. Carries a range of punishment of not less than 2 years in prison or more than 10 years in prison. And a fine, if imposed, not more than $10,000. That's if you're convicted and sentenced on such crime. I see that the agreement in your case, the recommendation of the state is that the court review the evidence, and if it finds that there's sufficient evidence to convict you, that the court defer a finding of guilt. That means that the court not adjudicate your guilt or convict you today, but rather place you on community supervision for 4 years and assess a fine of $750, order you to pay court costs and reimbursement fees. If the court were to accept this plea agreement, and as Mr. White said, during your period of community supervision, if you violate any term or condition, the state can file a motion to adjudicate your guilt. That means to convict you in the court upon a hearing. If it found that you violated any term or condition, the court could do several things, including up to revoking your community supervision, adjudicating your guilt, convicting you of this offense, sentencing you up to the maximum 10 years in prison and imposing a $10,000 fine. Do you understand that?
Yes, sir.
Understanding all of those things, Mr. Payne, do you still wish to go forward?
Yes, sir.
All right, ladies, is there a problem?
No, sir.
It sure does look like there's a problem, because I'm more focused on what's going on behind me, on these gentlemen and y'all. So, ladies, if there's a problem, step outside and handle your business. I'm sorry, Mr. Payne. All right, and I'm sorry, Mr. Payne, I lost my focus, okay? So understanding all of these things, you still wish to go forward in your plea, is that correct?
Yes, sir.
All right, then, Mr. Payne, how do you plead to evading arrest, and detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And Mr. Payne, has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. White, is there any objection to the state's evidence? All right, State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we addressed it close.
Anything further from the defense?
President.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict Mr. Payne of this offense. The court will follow the recommendation of the state, the agreement between the parties. The board hereby defers the finding of guilt, places Mr. Payne on 4 years community supervision, assesses a $750 fine, $290 in court costs, $40 reimbursement. Why is Mr. Payne a resident of Van Zandt County or, he lives in Carrington? So he's a resident of Texas and anticipating his probation being transferred to Tarrant County. All right, Mr. Payne, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm have you come forward, deputy patients will take your fingerprint, and then these ladies will tell you more about the probation status. Mr. Noriega, are you ready, sir? You ready? Yes, Mr. Valencia Fulton, you come forward, sir. Oh, thank you. Oh, here. Oh, yeah, that's. All right, so, sir, do you go by Valencia, do you go by Fulton, do you go by Valencia Fulton, do you go by? Okay, Mr. Valencia Fulton, if you'll raise your right hand, please the vote. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God? Yes. Thanks, so you can lower your hand. All right, this is in cause number CR 23-20, CR 23-23, CR 23-21. Mr. Valencia Fulton, are you a United States citizen who reads, writes, and speaks English? Yes, sir. Have you ever been diagnosed with a mental condition? No, sir. In this case, you've been represented by your attorneys, Ms. Sally Wilton, and then Mr. Noriega today. Is that correct? Yes, sir. Are you pleased with their representation of you? Yes, sir. You feel like you've had enough time to talk with them about your cases, that you've had all of your legal questions answered? Yes, sir. Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Noriega, do you believe that Mr. Valencia Fulton is competent today?
Yes, Your Honor.
Have you explained to him his rights as they pertain to each one of these cases and the plea agreements herein?
Yes, Your Honor.
Do you believe that he's intentionally, knowingly, and voluntarily entering into these agreements?
Yes, Your
All right, Mr. Valencia Fulton, in cause number CR 2320, you are charged with a second-degree felony offense by indictment, aggravated assault with a deadly weapon. If convicted and sentenced, that would carry a range of punishment of not less than 2 years in prison or more than 20 years in prison. It carries a possible fine not more than $10,000. In CR 23-23, you're charged by information with a Class B misdemeanor offense of driving while intoxicated. A Class B misdemeanor carries a range of punishment of confinement in the county jail not to exceed 180 days or a fine not to exceed $2,000. I see that there are plea agreements in each one of your cases. It appears that in the felony case of aggravated assault with deadly weapon, you plead guilty to that offense. The state's recommendation to the court is that the court defer a finding of guilt, place you on 5 years community supervision, order you to pay a $2,500 fine plus court costs and reimbursement fees, and the state would be dismissing CR 23-21, another aggravated assault with a deadly weapon in conjunction with that plea. With regard to the driving while intoxicated Class B misdemeanor, state's recommendation upon your plea of guilt is confinement in the jail for 67 days, would be receiving credit for 67 days of time already served, plus fine, restitution, court cost, and reimbursement fees. Is that your understanding of the plea agreement today? Yes, sir. That's what you're asking the court to approve? Yes, sir. All right. All right, then, sir, how do you plead to aggravated assault with a deadly weapon and driving while intoxicated? Are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes? Yes, sir. Has anyone threatened, forced, or pressured you to plead guilty? No, sir. All right, court will accept the defendant's plea of guilt in each cause. Mr. Noriega, any objection to State's Exhibit 1 in each case?
Honor.
State's Exhibit 1, stipulation of evidence is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial conviction. Anything further from the state?
Yes, Your Honor, there is a victim impact statement submitted for this case. We've just asked the court to take note of that before pronouncing sentence.
Thank you, Sergeant. Anything else from the defense?
Nothing for the defense, Your Honor.
The court's going to review the evidence and the victim impact statement. Ms. Heisel is I've reviewed, for the record, I've reviewed the victim impact statement. I've reviewed the evidence submitted for the plea. Is the victim supportive of this plea?
Your Honor, I have not been directly the victim. I don't know if Ms. Cheney has reached out. And then just maybe approach the bench.
Right. All right, state has reviewed the evidence, state has reviewed the victim impact statement. Court will follow the recommendations of the state. In the agreement of the parties, the court hereby defers the finding of guilt in CR 23-20 on the charge of aggravated assault deadly weapon. Or will defer a finding of guilt. Place Mr. Valencia Fulton on 5 years community supervision, order him to pay a $2,500 fine. Court costs of $290, $35 reimbursement fees, and the court dismisses under section 1245 Texas Penal Code, cause number CR 23-21, aggravated assault with a deadly weapon. CR 23-23, driving while intoxicated. Court follows the plea agreement and the recommendation. The court hereby assesses the guilt of Mr. Valencia Fulton for a class B misdemeanor. Convicts him, orders him to serve 67 days in the county jail. The court will award him 67 days credit towards his incarceration for time already served. Court orders him to pay a $100 fine, $60 restitution, $270 court cost, $15 in reimbursement. All right, Mr. Valencia, hold down, have to come forward to be fingerprinted with the deputy, and then you'll report to probation for further instructions. Mr. Schmidt, are you ready? Yes. Who are you ready on? Who do you want to call?
Jason Briggs, may I approach you?
Yes, you may. Mr. Briggs. CR 22-370.
Dismiss Mr. Briggs' case, we'd ask the court. Later.
Ms. Heisel, here's that victim impact tracking form on Mr. Flincy. All right, state has tendered in deposit for CR 22-370, state versus Jason Coley Briggs, a motion to dismiss. Court is hereby granting the state's motion, signing the order of dismissal. Mr. Briggs, have you paid in towards your pretrial release any financial contributions towards your attorney fees? All right, so the court's going to order that those be paid to Van Zandt County to reimburse the county for your legal fees paid on your behalf to Mr. Schmidt. Any objection to that? No, sir. No. All right, you're free to go. Thank you, sir. Schmidt, who's next? I thought Mr. Tigram said that was set this afternoon.
Judge, he's on bond. I think it was originally set this afternoon. I did provide Ms. Tabraham with some documentation. I did not expect it, but on his copy, it's here this morning. I'd like to reset him for a plea.
So what's the issue?
Judge, Mr. Davidson, according to medical documentation, has an acute dental infection scheduled for dental surgery this afternoon, according to the paperwork we provided. And ultimately, once that surgery's done today, I think he has one more post-op this month. So after that, we can get on that.
Who's extraction?
According to the documentation, the dental surgeon stated that he had acute infection in his mouth. So whatever, she didn't specify the surgery.
Well, I'm trying to think. What I'm wondering is if we could reset this to Thursday. I heard you say post-op later this.
So post-op. Or something like that. This far.
So let me think about it. We'll call you back up here. Are you ready on that?
Preston Wilson.
Preston Mitchell Wilson, CR 2383. Softball. All right, this is cause number CR 2383, seven for arraignment. Court has found that Mr. Wilson has applied for court appointed counsel. The court has reviewed his application, finds him to be indigent at this time. Court has appointed Honorable Richard Schmidt to represent Mr. Wilson. Mr. Schmidt, have you had an opportunity to go over the indictment with your client?
We have, Judge, the indictment lays out Mr. Wilson's name correctly. Stands charged with being a guilty, ask for free trial.
All right, court will find that Mr. Wilson has waived the formal requirements of arraignment. Court will the court will enter his plea of not guilty into the record and will set this matter for pretrial hearing. Available on June 13th. June 27th at 9 a.m. Mr. Wilson, you signed the condition of pretrial release, have you not? You read over those with Mr. Waddell, you understand what's required of you? You understand that if you violate any of those, you force to revoke your bail, put you back in jail? They're going to comply with each and every word of the court, right? All right. Once Mr. Schmidt says he's done with you, you're free to go.
And you got this way, which is.
Yes.
Brad Brewer.
Brad Brewer. This is cause number CR 23-6.
Because I believe we're on a pre-trial.
Correct.
At this point, we don't have any contested pre-trial motions on file. We have some issues with restitution that I'm gonna take up this current issue. So, yes.
All right, court finding that there are no pretrial motions, court sets Mr. Brewer for docket call June 27th at 9 a.m. Once he signs, he gets the yellow copies free to go. Bates. Robert Earl Bates, CR 23-25. Mr. Bates is set for pretrial.
Correct, Jim, that's the same, and that's.
Court finding there are no pretrial motions, sets docket call June 27th at 9 a.m. Once Mr. Bates signs and gets the yellow copies free to go. Jessica Swindle. CR 2319. Swindle set for free trial.
That's correct, Judge. Test trials for that change.
All right, there being no contested pretrial motions, court sets docket call June 27th at 9 a.m. She's free to go. Fulbright. It's cause number CR 22-214.
That's correct, Judge. I have with Story, I have, for the unit yet, there's no objection from the state, additional pretrial, Brian's case.
All right, there being no objection, court sets an additional pretrial June 27th at 9 a.m. Jacob Wyatt Myers, CR 23-30. Myers also set pretrial.
That's correct, Judge. Look at that's the trials. Change it, so. Time to call it.
Being no pretrial issues, court sets Mr. Myers for docket call June 27th at 9 a.m. Once he signs, he seal a copy. Katrina Lee Anders, CR 22-351. It's also cause number CR 23-87. Ms. Anders, a resident of Louisiana. We talked to probation about transferring.
We did meet with Ms. Burns when we were here last. I think there's some debate on whether Ms. Sanders wishes to transfer. And ultimately, she has brought up proper identification necessary for that transfer is requested by Ms. Burns. That's what the bad choose to go. So I think we're good.
You go over and review the standards. She could go and she's indicated she did not want to transfer, but if she chooses. She says, all right, Ms. Sanders, if you'll raise your right hand and place you on the oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So,
Yes, sir.
all right, you can lower your hand. All right, Miss Anders, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Like you've had enough time to talk with him about all of your cases and that you've had all of your legal questions answered?
Yes, sir.
You've signed paperwork here today with your plea agreement. Is there anything that you've read over and signed that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Sanders to be competent today?
I do.
You've explained to her her rights as they pertain to both cases and the plea agreements and also the advantages and disadvantages of the deferred adjudication plea. Yes. And do you believe that she's entering into these pleas intentionally, knowingly, and voluntarily?
I do.
Ms. Anders in cause number CR 22-351 for the charge of possession of a controlled substance, penalty group 1, less than 1 gram, state jail felony. Does carry a range of punishment of not less than 6 months in state jail and not more than 2 years, and a fine if imposed not more than $10,000. In cause number CR 2387, you're charged with driving while intoxicated, a class B misdemeanor, which carries a range of punishment which cannot exceed more than 6 months in the county jail or a fine more than $2,000. I see that the plea agreement in your cases are different. The felony case on possession of controlled substance, state upon your plea of guilt is recommending that your guilt be deferred, that you be placed on community supervision or probation for 3 years, that you pay a $2,500 fine, $290 court cost, $535 in reimbursement fees, and $180 in restitution. On your misdemeanor charge of driving while intoxicated, the plea recommendation is that you be convicted of that offense, and you be sentenced for 2-3 days in the county jail, that you would receive credit for 3 days of time already served, that you would pay a $100 fine, $270 in court costs, and $35 in reimbursement fees. Ms. Sanders, is that your understanding of the plea agreement in each case?
Yes, sir.
You understand, Ms. Sanders, that if the court approves your plea agreements and places you on deferred community supervision, that if during the next 3 years you violate any of the terms of your community supervision, the state can file a motion to adjudicate the guilt, bring you back before the court, ask for a hearing, and during the hearing, the state produces to the court evidence that proves that you violated these conditions. The court can do a number of things, including evicting you of this offense, revoking your community supervision, and sentence you to prison anywhere from that minimum 6 months up to the maximum 2 years in the state jail. Prison system. Understand that?
Yes, sir.
And understanding that you still wish to go forward with this plea, all right?
Yes, sir.
All right, and understanding the admonishments, understanding the risk, Sanders, how do you plead to possession of controlled substance, penalty group 1, less than 1 gram?
Guilty.
How do you plead to driving while intoxicated?
Guilty.
Are you pleading guilty to each one of these crimes because you are guilty of committing each crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to either one of these crimes?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to states 1 in each case?
Objection.
All right, court admits states exhibit 1 in each case, takes judicial notice of the defendant's judicial confession. Is there anything further from the state? Sure.
All right, Judge, it's unclear from the jail system. We believe these to be the only two charges that Ms. Anders has in this county. It is our intention to resolve all of her business. It's unclear from the jail system whether an additional charge was added, in March. We have not received a case for that, so I've just put on the record. We do believe this resolves all of her business, and if we do get a case forwarded in the future from that March arrest date, state will decline those in accordance with this plea agreement.
What does the new charge appear to be? Is it related to this all?
Judge literally doesn't say, so
And Judge, it's my understanding that at one point in time, this court violated Ms. Andrews' bond, revoked her bond. She was on bond for a misdemeanor DWI as well as a possession. And her booking after that showed 2 possessions, but it didn't show that previously. So it's my opinion that it's most likely a booking error at the time the bond was revoked by you.
Anything further from the state? Anything further from the defense?
No, sir.
All right, the court having reviewed the evidence, in each case finds that there is sufficient evidence to convict Ms. Anders of each cause, or will follow the agreement in each case, file number CR 22-351, the court confers the finding of guilt, places Ms. Anders on 3 years supervision, orders her to pay a $2,500 fine, $290 court cost, $80 restitution, orders her to reimburse Lansing County $535. In cost number CR 23-87, the court follows the agreement, convicts Ms. Anders of driving while intoxicated, Class B misdemeanor, assesses her punishment in 3 days confinement in the county jail, orders that she receive credit for 3 days of time already served. Court orders her to pay a $100 fine, $270 court cost, $35 reimbursement fees. Ms. Anders, you hereby remain in the probation department so they can carry out the terms and conditions of the sentence. And have you come forward to be fingerprinted with the deputy, and then after that, you're going to report to the probation officers. Sir? Yes, sir. Mr. White, are you ready, Mr. Watson?
No, you're on that second step from that.
It's okay. It's my understanding that there's no allocation. Is that correct?
That's correct.
If the defense is ready, state's ready, we can proceed now.
Wait, he's not here.
Oh, he's not here. Okay, I thought he was.
Oh, well, as soon as he gets it.
Okay. Very good. Mr. Vargas. Yes, sir. While we're setting up the defendant, he's getting his headphones on. And test everything out. While we're doing that, I'm gonna go ahead and place you under oath. Okay, raise your right hand. If you go ahead and state your name and license number, please. Can you state your name and your license number, please, Mr. Vargas? Thank you, Mr. Vargas. Mr. Vargas, do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God. Thank you. I'm gonna give you a moment so you can test out, make sure our technology is working. For Mr. Felix Diaz, this is Felix Alejandro Vasquez Diaz. If you'll go ahead and speak with him and make sure everything's working well. Great. All right, thank you. Okay, so the court calls cause number CR 23-28 State versus Felix Alejandro Vasquez Diaz. We're set for pretrial today. Mr. Altum, any contested pretrial motions or pretrial issues?
Not at this time, Your Honor. I've just received an offer today and then I need to go over that and discover my client. I've requested an additional pretrial setting before we get set on docket call so that I can make sure he's fully aware of everything that's going on in the case.
The objection from the state? Today's pretrial, he says he wants more time to go over the things with his client so that he's fully informed before we go to docket. All right, court will reset Mr. Diaz then for an additional pretrial. Charlton, do you have your calendar available?
I do.
All right, I'd be looking at June 13th and 15th.
I'm available on the 15th.
All right, court sets Mr. Diaz for an additional pretrial hearing on June 15th. That'll be at 9 a.m. And Mr. Alton, I need to know why Mr. Diaz was not here at 9 a.m. as he was ordered to be last time and as he signed his notice of appearance of a date and time.
Yes, Your Honor, there was some confusion between this court as well as the court downstairs. He has two cases that were sent downstairs. I believe week before last. Those cases got mixed in with this case because for whatever reason, the county court of law set he has second misdemeanor in May, and at the time he spoke about it like other thing. The interpreter was gone, and I realized he had no idea that these cases were different, that he needed to show up at separate times. So I attempted to explain that he still needed to show up today with Google Translate. Obviously that didn't work right. And so this morning I was calling, got numbers from him, someone that could speak English. And so I tried to explain them the situation, and they made sure he got here. Obviously it wasn't in time for the appointment with the interpreter at 9:30. But I now have a number of someone that is close to him that I can hopefully explain some of that to avoid something like this.
Do you know if he has anyone that he's in his family or that he can rely on that speaks English and can translate for him at home?
I'm not aware of anyone at home. I spoke with his boss's wife this morning, and so I was contacted to make sure he got here and avoided upon signature. I've planned to call her once we're done here and try and see if I can get somebody at his house, or at the very least ask her to make herself available so that we can avoid something like this.
And Mr. Vargas, will you ask Mr. Diaz if there's anyone that he could recommend that Mr. Alton be able to call to be able to relay information to him at work or at home?
Ese, eso no, policía de Super Spring. Policía de Super Spring. Policía de Super Spring. Emory. Del condado de Rice. Habla español. Super Spring. Está en Emory. Emory. Sí.
Police officer? Is he related to a police
Sí,
officer?
él habla español. Estoy en probation con él. Estoy en probation con él.
His probation officer. No, I want someone that is readily available at his work or at his home that Mr. Alton can call and relay information as he needs it that can translate. I don't want a member of government or anyone else. I want someone in his personal life. If Mr. Alton calls his boss's wife, is that someone that he can talk to?
Es la esposa de mi patrón.
That's the best contact. Mr. Alton, you already have her.
I do.
All right, Mr. Diaz, do you understand that you're to be back in this court on June 15th at 9 a.m.? I believe you're in the English. You can let him know he may have other court dates in another court, but I'm not worried about those. I'm worried about this court and this court date. All right, so Mr. Diaz, we'll see you back June 15th at 9 a.m. and Mr. Alton will be in contact.
Your Honor, I've just, so we don't have this issue again with this misdemeanor case, did the interpreter let him know that he was set downstairs on June 21st at 10 a.m.?
Sure. Can you do that, Mr. Vargas? Mr. Alton wants you to relay to Mr. Diaz that he has an additional court setting in the lower court downstairs on June 21st at 10 a.m.
Sí, porque me están dando cortes que yo no tenía fecha. Tengo los papeles, pero no tengo fecha de corte y me dijeron que viniera.
I just gave him the court dates. I gave him 2 court dates. I want him to write, hang on, I want him. I want him to write on those birthdays. So you tell him what they are. You ready? They're June 15th at 9 AM. June 15th at 9 AM in this court. That's court setting number 1. June 15th at 9 AM. And the other one is June 21st at 10 AM downstairs. Right, Mr. Alton?
Yes.
Have those dates right. June 21st, 10 AM downstairs. All right. He's free to go. I'll see you. Yes, thank you, Mr. Vargas. I do appreciate your help and being able to be available on short notice. Thank you, sir. Are you ready? Yes. Are you ready? Mr. Hitt, come forward. All right, Mr. Hitt, if you'll raise your right hand, this is possible for CR 22379, State versus Sydney Kyle Hitt. Mr. Hitt, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. Yes. All right, you can lower your hand. All right, Mr. Hitt, your name is Sydney Kyle Hitt, is that right? Mr. Hitt, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with a mental condition? You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney? You feel like you've had enough time to talk with him about your case, had all your legal questions answered? Yes. Is there anything about the paperwork that you've read over and signed today that you do not understand? Yes. All right, Mr. Schmidt, do you believe that Mr. Hitt is competent today?
I do.
You've explained to him his rights as they pertain to this plea agreement.
Yes.
And you believe that he is entering into this plea intentionally, knowingly, and involuntarily. Is that correct?
Correct.
All right, Mr. Hitt, you are charged by indictment with the offense of criminal mischief greater than or equal to $2,500, less than $30,000. That is a state jail felony. However, it appears that the plea agreement in this case is that you would be prosecuted under section 1244B for a class 8 misdemeanor, which would carry a range of punishment of not more than 365 days in the county jail and a fine not to exceed $4,000. I see the plea agreement is upon your plea of guilty, the state is recommending that your punishment be assessed at 75 days in the county jail. You would receive credit for 75 days of time already served, a $3,500 restitution, $270 court cost, $560 reimbursement fees, and the DA's office would be dismissing cause number 2022-432, a violation of a protective order. Is that your understanding of the plea agreement? All right. Mr. Hip, understanding the plea agreement, understanding the range of punishment, how do you plead to criminal mischief, a class A misdemeanor? You pleading guilty to that crime because you are guilty of committing that crime? Yes. Has anyone threatened, forced, or pressured you to plead guilty today? Yes. All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to states one?
No.
States one is admitted and the court takes judicial notice of Mr. Hibbs' judicial confession. Anything further from the state?
In regards to patient statements and clients that are duties or to patient to get contact since all the steps to get contact.
Thank you, Mr. White. Anything further from the defense?
No.
All right, court's going to review the evidence. All right, court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Hibb of this offense. Court will follow the plea agreement. Court hereby convicts Mr. Hibb of class A misdemeanor criminal mischief. Assesses his punishment at 75 days in the county jail, awards him 75 days credit towards his sentence. Orders him to pay $3,500 restitution to the victim named in the judgment. Court also orders him to pay $270 court costs and $560 in reimbursement fees to maintain county. Court dismisses cause number 2022-432 violation. Are remanded to the custody of the Van County Sheriff, so we can carry out the terms and conditions of the sentence, having come forward to be fingerprinted with the deputy. Okay, we did get the misdemeanor transfer. Just going to strike Judge Winter's lead here. And Judge, I think insurance. All right, this is cause number CR 22-94, State versus Taylor, Leon Davidson. Mr. Davidson was set to plead this afternoon. In light of the request by the defense, the court will reset Mr. Davidson to enter this plea with the court. We'll reset to May 30th. Yes, you're free to go. All right, this is cause number CR 22198, State of Texas versus Christopher Storm Watson. Mr. Watson, if you'll raise your right hand, I'm gonna place you under oath. So do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God? Yes, sir. Lower your hand. Mr. Watson, are you a United States citizen who reads, writes, and speaks English? Yes, Your Honor. Have you ever been diagnosed with a mental condition? No, Your Honor. In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation? Absolutely. You feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Yes, Your Honor. Is there anything about the paperwork that you've read and signed today that you do not understand? No. Mr. White, do you believe Mr. Watson to be competent? Yes, Your Honor. You've explained to him his rights as they pertain to this case. I have, and I believe he understood fully what the ramifications of everything we're doing. And you've explained to him the advantages and disadvantages of a deferred adjudication plea. I sure did. All right, Mr. Watson, you are charged with a second-degree felony offense of accident involving death. A second-degree felony offense carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine, if imposed, not more than $10,000. I see that the plea agreement the state's recommending is that upon your plea of guilt, that a finding of guilt be deferred and your punishment be assessed at 8 years, 8 years placement on community supervision with a $2,500 fine, $290 court cost, and $70 in reimbursement fees. I see one fine says 2,550 and the other says 2,500 even. So just a fine, it's 2,500. I believe that. I believe there was a place where there was a $50 like transportation fine. Does say on the second page that there's a general fine of 2,500 and a state traffic fine of 50, so 2,550. That may be correct. State. EA is imposed fine of 2,500. There is a state imposed fine of $50. All right, Mr. Watson, is that your understanding of the plea agreement as well? All right, understanding the range of punishment. Minimum 2 to maximum 20. You understand that if I approve this plea agreement and place you on community supervision, if during the period of your community supervision or finds that you violate any of the terms and conditions of your community supervision after a period, the court could do a multitude of things, including adjudicating your guilt, means convicting you of the offense, revoking your community supervision, and or assess punishment from the minimum 2 years all the way to the maximum of 20 years. Understanding that, you still wish to enforce? Yes, Your Honor. All right. Then, Mr. Watson, how do you plead to accident involving death, a second-degree felony? Guilty, Your Honor. Are you pleading guilty to this crime because you are guilty of committing this crime? Yes, Your Honor. Has anyone threatened, forced, or pressured you to plead guilty today? No, Your Honor. The court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence? No objection. The state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Judge, just record, it's a big statement of which the coroner has feedback. All right, court will review the victim impact statement. Anything further from the defense? That's the. All right, court's going to review the victim impact statement and the All right, the court has reviewed the evidence. Court finds sufficient evidence to convict Mr. Watson of this offense. Court will follow the agreement. Recommendation of the state. Court hereby confers a finding of guilt on the second degree felony offense of accident involving death. Court places Mr. Watson on 8 years community supervision. Orders him to pay a fine of $2,550. Court costs of $290, reimbursement fees of $7. All right, Mr. Watson, hereby remains the custody of the probation department. So they carry out the terms and conditions of the same. That for fingerprinted. They will need to be probation officers. Signing. All right, Mr. President. Cause number CR 21183, State versus David John Pesnell. This is a sanctions court hearing. Mr. Pesnell, the probation department is filing a motion to revoke your community supervision. So you're going to be taken into custody at this time. Yes, go ahead and ask. Mr. Jackson. All right, this is sanctions court hearing for Jaquavian Intron Jackson, cause number CR 21361. Let's see, Mr. Jackson. Some of the things that you were required to do was pay money to the probation department, to the court, work your community supervision hours, enroll in your drug offender class. And I think it's the last time you were in court, we talked about these things, right?
Yes, I.
Right. So they've indicated to me that you've not done any of those things.
That's fair.
It's a problem. It's not for me, but for you. So what I'm gonna do, I want you to come back to court. I'm gonna set you again. Set you on Thursday, June 1st. Sanctions Court. I'm gonna have to figure out what I'm gonna do with you. All right, you're not leaving me many options. So I'll see you back on June 1st. Yes, you're free to go. Yes, let's just have the turn attached. All right, Republicans, just what there you are, sorry. I think you know what I'm gonna say down here. You know what I'm gonna say down. Tell me what I'm gonna say. That's right. Following motion. So look at me for a second. When are we gonna stop this? No, look at me, speak up.
I go on the night, I was supposed to go on the 19th to actually put on my medication and actually prescribe, so I actually deal with my anxiety. I asked, justify my reason behind it. I understand there's been justifying my. That's my call. I come back with it. Actually figure out what.
Well, you're gonna be taken into custody today for your violations on that warrant, so. If you're being opposed to bail, get your medications figured out. Figure out how you stay out of this world. Okay. One day I'm gonna take the medication. Right, state, I believe that, yeah, everyone showed up, is that right? Might be. All right, I'll see you all at 1:30, y'all have a good lunch. I'm gonna call about Davis, maybe in federal custody and Henderson County. We have them. I don't know what's going on, so I'm gonna see which way. Henderson County said they ain't got any. All right, that finishes our morning docket. We will resume at 1:30 at the jail.